The first time I heard the word sold, I was standing in the middle of our family's soybean field with red Tennessee clay on my boots and wind pushing low across the rows like it was carrying gossip. "We sold the farm," my father said. No build-up, no explanation, just a statement, loud enough for the two hired hands near the equipment shed to hear. Beside him stood my mother, Elaine Whitmore, arms folded across her chest, the corners of her mouth pulled into that small, familiar smile, the one she saved for moments when she corrected me in front of church friends. Behind them, a man in a pressed button-down leaned against a black SUV, holding a leather folder against his chest as though our land were nothing more than a scheduled appointment. Blue Horizon Land Group. I didn't yell. I didn't ask why in a shaking voice. I just blinked once and said, "What's the probate case number?" My father's jaw tightened. "Your grandfather is gone, Clara. The land comes to us. We handled it." "I'm asking for the probate case number." My mother let out a soft laugh. There she goes, always thinking she's the one in charge. The man with the folder stepped forward, offering a professional smile. "Ma'am, we've executed a purchase agreement. We're very excited to bring development to Ashford County. We just need your signature acknowledging the transfer so everything moves smoothly." He extended a stack of papers toward me. I didn't take them right away. I let them hang between us like a test. "Is the deed recorded?" I asked. "It's in process," my father snapped. "Stop being dramatic." "I'm not being dramatic. I'm following procedure." That made him flush. He shoved the papers into my hands hard enough that the corner struck my collarbone. "Sign it and stop acting entitled. You don't own anything here." I looked down. No probate reference, no instrument number from the recorder's office, just a vague paragraph about consent and cooperation. If it was legitimate, it would survive daylight. But I already knew why they were standing here, in the middle of a field with an incomplete contract and that particular brand of confidence. My father had been carrying debt in silence for 12 years. Not the reckless kind, no gambling, no bad habits, but the kind that accumulates slowly through seasons of rising seed prices, 2 storm-damaged roofs, and 3 straight years of flooding that took a portion of the harvest. He had borrowed to survive, and much of what he'd borrowed had gone toward keeping alive the very land he knew wasn't legally in his name. That wasn't a reason to excuse what he'd done, but it was a reason to understand why he had done it. "When was probate opened?" I asked calmly. My mother's smile sharpened. "We didn't need to open anything. Harold Whitmore didn't leave complications." Complications. That was the word they were using for my grandfather's estate. I thought about the summer before he passed, the way he sat on the porch at dusk, a manila envelope resting on his knee. He wasn't sentimental. He wasn't forgetful. He was precise. "People change when land turns into money," he had told me quietly. At the time, I thought he meant the neighbors. I didn't realize he was talking about his own son. "If everything's clean," I said evenly, "you won't have a problem showing me the probate file and the recorded deed." My father stepped closer. "Don't do this." "Do what?" "Embarrass us." Behind him, the Blue Horizon representative checked his watch. I handed the papers back. "I'm not signing anything on the hood of a truck without recorded documentation. If the transfer is real, it'll be in the public record." My mother leaned in slightly, voice low and sweet. "You always did need attention." I didn't respond. Silence unsettles people who expect emotional reactions. Instead, I looked past them, at the farmhouse porch where my grandfather used to shell peas in the evenings, at the oak tree he refused to cut down even when lightning split a limb, at the stretch of pasture he measured himself with a steel tape measure and a notebook. This wasn't just acreage. This was intention. "You'll see bulldozers by next week," my father said loudly, making sure the workers could hear. "Survey crews already scheduled." "That depends," I replied. "On what?" "On what the county says." He scoffed. Paperwork doesn't stop progress. It does when the paperwork is wrong. I walked to my truck without slamming the door, without peeling gravel, without giving them a scene to feed on. When I pulled away, I caught my mother watching in the side mirror. Not worried, not nervous, confident. That told me everything. If they were this sure, it meant they believed the record was clean, or they believed no one would bother to look. 20 minutes later, I parked outside the Ashford County Clerk and Records Office. The building was low brick, sun-faded signage, the kind of place that smells like toner and old carpet. Inside, a small sign read, "All records are public. Good." I stepped up to the counter and waited until the clerk looked up from her screen. "I need the deed history for the Whitmore farm parcel," I said, keeping my voice steady, "and the probate file for Harold Whitmore." She adjusted her glasses. Relationship? Granddaughter. Her fingers moved across the keyboard. The clicking echoed softly in the quiet room. Then she paused. Not the normal pause of someone searching, the kind of pause that means something unexpected just surfaced. She leaned closer to her monitor. "There was a transfer recorded yesterday," she said slowly. My pulse didn't spike. It narrowed. "Recorded from whom?" I asked. She clicked again. Her eyes shifted just slightly. And for the first time since my father said the word sold, I felt the ground under this situation begin to change, because whatever she was seeing on that screen, it wasn't simple. The clerk didn't speak right away. She clicked once, then again. Her expression shifted, not dramatic, just tighter around the eyes, the kind of look someone gets when paperwork stops being routine. "Parcel transfer was recorded yesterday afternoon," she said carefully. "From whom?" I repeated. She turned the monitor toward herself instead of toward me. That told me enough. "It lists the grantor as the estate of Harold Whitmore." My hands went cold. "There's no probate case open," I said evenly. "So how did the estate convey property?" She glanced at me, assessing. "That's what I'm checking." The printer behind her hummed as she generated the last two recorded instruments. 2 sheets slid out with barcodes across the top and a thick black recording stamp on the bottom. She handed them to me. Blue Horizon Land Group was clearly listed as grantee. Document type, warranty deed. Attached authority, affidavit of heirship. I didn't react outwardly. "Is there a probate file under Harold Whitmore?" I asked again. She clicked into another system, searched by name, date of death, nothing. "No active probate case in Ashford County," she said, "not filed here." "Then the estate had no court-appointed executor," I replied quietly. She hesitated. "There is something else." She opened another tab, one that didn't look like the standard public search interface, a separate record type. "Deposited will packet," she read softly. "Deposited for safekeeping?" I asked. She nodded once. "Filed years ago, never admitted to probate." That felt like a door unlocking somewhere deep inside my memory. My grandfather and that manila envelope on the porch. "Can you open it?" I asked. She leaned closer to her screen. The fluorescent light reflected faintly in her glasses. Then her eyebrows lifted, just slightly. "There's an access log," she murmured. "What does it show?" She clicked. The room felt smaller. "It was viewed yesterday morning," she said. My pulse slowed instead of quickening. "By whom?" She didn't answer immediately. She scrolled. Her lips parted, then pressed thin. "Viewed at a public terminal, request under the name Elaine Whitmore." The air in the office seemed to thin. "Timestamp?" I asked. 10:42 a.m. And the deed recording? 3:15 p.m. My mother had accessed the deposited will packet hours before the estate transferred the land. "Did she request copies?" I asked. Another click. "Yes," the clerk said quietly. Printed copies were purchased. I felt something settle into place. This wasn't confusion, this wasn't ignorance, this was calculation. But I also understood. Not the cold calculation of someone purely malicious. This was the calculation of a person drowning, grabbing at whatever floated past. My father couldn't pay his debts. My mother had watched the home they built over 30 years slowly erode on bank statements. That didn't make them right, but it made them human and wrong in equal measure. And my grandfather had known. That was why he'd filed the will 6 years ago. "Please print the will packet," I said. "Certified copy." She studied me for a long second, then nodded and stood to retrieve a supervisor. A man in a gray cardigan joined her at the counter, his badge identifying him as records supervisor. "You're requesting certification of a deposited will copy?" he asked. "Yes, and certified copies of the recorded deed and affidavit of heirship." He looked at the access log, then at me. "You understand," he said carefully, "that a deposited will isn't legally effective until admitted to probate." "I understand," I replied. "That's about to change." The printer started again, longer this time, multiple pages. The supervisor watched the machine like it was producing evidence in a trial. When the stack finished, he added a certification page, stamped it, and signed with slow, deliberate strokes. He slid the packet across the counter. I didn't rush. I turned the first page slowly. Last will and testament of Harold Whitmore. My grandfather's name printed clearly at the top. Date, witness signatures. Then I reached the section that mattered. The legal description of the farm. Meets and bounds, parcel number, acreage. Precise. Unmistakable. And then the line that changed everything. I devised the Whitmore farm in its entirety to my granddaughter, Clara Whitmore. Not shared, not divided, not contingent, solely. Further down, I appoint Clara Whitmore as executor of this estate. My hand stayed steady, but my skin went cold. There was also a non-contest clause. Any beneficiary who attempted to challenge or interfere with the terms would forfeit their interest entirely. I flipped to the back page. Deposit stamp. Date from 6 years ago. My grandfather hadn't forgotten. He had planned. I looked up at the supervisor. If this will was deposited years ago, how did an affidavit get recorded yesterday claiming there was no will? He folded his hands. "We record documents that meet statutory formatting requirements. We do not adjudicate truthfulness. That's for the court." "So the affidavit claimed intestate death?" "Yes." "And it was notarized?" "Yes." I nodded once. "Print the affidavit," I said. "Certified." Minutes later, I had 3 stacks in my hands, a certified will copy, the certified deed and affidavit, and the access log with payment receipts showing my mother had purchased copies of the will packet. I stepped away from the counter and pulled out my phone. I didn't call my parents. I called Rachel Kane. Rachel had been my college roommate before she became a lawyer, the only person I'd ever seen read a contract while eating a sandwich without dropping a single crumb. We hadn't spoken much over the past 2 years. Life, distance, the ordinary drift that thins friendships without anyone meaning it to. But when I called, she picked up on the first ring. "Rachel," I said when she answered, "they recorded an affidavit claiming Grandpa died without a will." Pause. I continued, "There is a will. It names me sole devotee and executor, and my mother accessed it yesterday morning before they recorded the transfer." Rachel went silent for a half-beat. "Clara," she said finally, voice sharp now, "you're going to file for probate today." "I'm still in the building." "Good. We open the estate, emergency petition, then we record a notice of pending action against the property immediately. We cloud that title before anyone touches the land." I glanced down at the deed. Blue Horizon thought they had clean ownership. They didn't. I said, "They scheduled a survey crew." Rachel's tone hardened. "Then we move faster." I hung up and turned toward the probate window down the hall. For the first time since my father said the word sold, I wasn't reacting. I was acting. And the record, unlike people, didn't blink when it told the truth. By the time I left the probate window, The estate of Harold Whitmore officially existed in the system. Case number assigned, petition filed, certified will attached. Rachel had emailed me 2 short documents while I stood in line: notice of probate filing and notice of pending action. Clean, direct, surgical. I printed them at the public kiosk and walked back to the recorder's counter. "I need these recorded against the Whitmore farm parcel today," I said. The clerk recognized me immediately. She reviewed the case number, checked formatting, then fed the pages through the intake scanner. 10 minutes later, she handed me 2 receipts. Instrument numbers, time-stamped, barcoded. "This is now public record," she said quietly. "Anyone searching title will see the dispute." "That's the point," I replied. Outside the building, I called Blue Horizon. The receptionists transferred me to their counsel, a man named Daniel Price. His voice carried that measured tone attorneys use when they suspect trouble but don't want to admit it yet. "My name is Clara Whitmore," I said evenly. "The farm parcel you believe you purchased is subject to an active probate case. A will was located and filed this afternoon. I've recorded a notice of pending action. Your title is clouded." Silence. Then, "Ms. Whitmore, your parents represented they had authority as heirs." I said, "They represented falsely." Another pause. "If what you're saying is accurate," he said carefully, "we will suspend entry until this is resolved." "Put that in writing," I said. He exhaled. "You'll have an email shortly." When I hung up, my phone buzzed almost immediately. From my father. "Don't make this ugly. Survey crew arrives at 7 a.m. Not a threat, a deadline. They were trying to create facts on the ground before a judge could stop them. I drove back to the farm as the sun dipped low over Ashford County. The fields looked the same, long rows, steady wind, but something underneath had shifted. When I turned onto the gravel drive, I saw the first change: fresh wooden stakes along the edge of the pasture, bright survey tape tied to each one, and on the gate, a new sign: "No trespassing, property under contract, Blue Horizon Land Group." My father stood beside it like he was unveiling a monument. My mother leaned against his truck, arms crossed, expression almost pleased. "You're trespassing now," my father said, before I even closed my door. "I'm the executor of the estate. Probate is open. Notice is recorded." He scoffed. "Paperwork doesn't stop progress." It already did. My mother tilted her head. "The sheriff will say otherwise." Right on cue, my phone vibrated. Voicemail. Unknown number. "This is the Ashford County Sheriff's Office regarding a trespass complaint." I played the message out loud so both of them could hear it clearly. My father's mouth curled slightly at the corner. "You called the sheriff on me?" I asked. "You're on Blue Horizon's property," he said flatly. I didn't argue with him. I called the number back. "Sheriff's Dispatch," a woman answered. "This is Clara Whitmore. I just received a voicemail about a trespass complaint. I need the incident number, reporting party, and responding deputy." Typing on the other end. "There is a complaint," she said cautiously. "Deputy en route. Reporting party, Elaine Whitmore." My mother didn't move, but her eyes flickered once. "Please note," I added calmly, "that a probate case was filed today and a notice of pending action has been recorded against the parcel. Instrument numbers available upon request." A pause. "I'll add that to the call," dispatch said. I ended the call and began photographing everything. The new sign, the fresh stakes, my parents standing at the gate. Documentation is quiet's power. 10 minutes later, a patrol SUV rolled up slowly, gravel crunching under its tires. Deputy Mark Harris stepped out, posture steady, body camera centered on his chest. "Ma'am," he said to me first, "you Clara Whitmore?" "Yes." He nodded, then glanced toward my parents. "They're alleging trespass on property under contract with Blue Horizon." My father stepped forward immediately.
We sold the farm. She refuses to accept it. Deputy Harris looked at me. Your side? I didn't give him emotion. I gave him facts. Probate case opened today, I said. Certified will filed. I am named executor and sole devisee of the farm. Notice of pending action recorded this afternoon. Title is flagged. He held out my hand. I gave him the recorder receipts, instrument numbers, timestamps, county seal. He read carefully. Then he spoke into his radio. Dispatch, confirmed recorded notice of pending action on Whitmore parcel. Instrument number. He read it off my receipt. We stood in the wind while static crackled. My mother leaned toward me, voice low. You think you're smarter than everyone. I didn't respond. The radio crackled back. Confirmed. Parcel shows active probate-related notice recorded today. Title flagged for dispute. Deputy Harris's jaw tightened slightly. He turned to my father. This is a civil dispute with active court filings, he said evenly. I'm not removing her for trespass tonight. My father flushed red. So she can just stand here? No, the deputy replied. Neither of you can alter the property while it's under dispute. My mother's voice sharpened. Survey crew is coming in the morning, sheriff's escort. Deputy Harris's eyes narrowed just slightly. No one's getting escorted onto land with a recorded pending action unless ordered by a judge. Silence stretched. I pulled out my phone and opened Daniel Price's email. Blue Horizon Land Group will suspend entry and development activities pending legal clarification. I showed it to the deputy. He nodded once. Good, he said. Then he looked back at my parents. And one more thing. False statements in a complaint can be addressed. My mother blinked twice. The wind pushed against the new sign, making it rattle softly against the gate. Deputy Harris took photographs of the stakes and signage, then returned to his SUV. As he drove off, my father stepped closer to me, voice tight. You think you stopped us? I think the record did, I replied. He pointed toward the fields. 7 a.m. tomorrow. I didn't argue, because by then, Rachel was already drafting something stronger than a notice, a temporary restraining order. And if the judge signed it before sunrise, 7 a.m. was going to look very different than my parents expected. At 5:43 a.m., my phone lit up in the dark. Rachel's name. I answered before the second ring. It's signed, she said. No drama, no build-up, just 2 words that shifted the entire morning. Temporary restraining order granted, effective immediately. I sat up in the cab of my truck where I'd slept parked along the edge of the north field. The sky was still slate blue, dawn barely stretching across Ashford County. Service? I asked. Filed electronically at 5:32, Rachel replied. Clerk stamped, sheriff notified. Blue Horizon Council copied. It's enforceable now. Across the pasture, headlights appeared at the end of the gravel drive. Right on schedule. 7 a.m. wasn't about construction. It was about intimidation. 2 white survey trucks rolled in first, followed by a pickup with Blue Horizon's logo on the door. My father's truck was already parked by the gate. My mother stood beside it, arms folded like she was waiting for a performance to begin. I stepped out slowly, printed copy of the TRO in my hand. The lead surveyor climbed down, stretching his back. Morning. We're flagged to start boundary marking. Not today, I said calmly. My father laughed under his breath. You and your paperwork. I handed the surveyor the court order. He skimmed the first page, then the second. His expression changed. What is this? He asked carefully. Temporary restraining order issued by Judge Eleanor Briggs, case number listed. It prohibits alteration, entry for development, survey staking, grading, or any material change to the Whitmore parcel pending probate resolution. My mother stepped forward. That's absurd. We own it. According to whom? I asked. She didn't answer that. Instead, she pulled out her phone. "We have a contract." "Contracts don't override injunctions," I said evenly. The surveyor cleared his throat. "Ma'am, this says violation could result in contempt of court." "That's correct." My father snatched the order from the surveyor's hands. He scanned it fast, eyes moving quicker than comprehension. "This is temporary," he said. "We'll fix it." "Maybe, but not today." Behind the trucks, another vehicle turned onto the drive. Sheriff's SUV. Deputy Harris stepped out again, posture calm but deliberate. He walked straight toward the cluster of trucks. "Morning." He didn't look at me first this time. He looked at my father. "We received notice of the court's order," he said evenly. "No work proceeds here." My father's voice tightened. "This is a family dispute blown out of proportion." Deputy Harris nodded once. "Which is why it's in court." Daniel Price appeared, in person this time, suit jacket already on despite the dust. He stepped forward from the pickup truck. "Deputy, we're reviewing the order. We believe the sellers had authority." "Then you'll argue that before Judge Briggs, not in this field." Daniel's eyes shifted to me. There was no arrogance in them now, only recalculation. This escalated quickly. It didn't escalate. It was always here. You just didn't look. He exhaled slowly. "We relied on representations made by Mr. and Mrs. Whitmore. That reliance may become relevant, because in legal language, it's the polite word for liability." The wind picked up, snapping the bright survey tape against the stakes they'd planted the night before.
Deputy Harris walked the fence line, taking photographs again. "For clarity," he announced, "any further entry for commercial activity without court authorization will be documented." The survey crew began quietly loading equipment back into their trucks. My father stared at them like betrayal was happening in real time. "You're just walking away?" he demanded. The lead surveyor shook his head. "We don't step into contempt orders." One by one, engines started. Blue Horizon's truck idled longer. Daniel approached me directly. "If the will stands," he said carefully, "this sale is void." "If the will stands," I replied, "there was never authority to sell." He nodded once. "And if misrepresentation occurred—" I didn't finish the sentence. I didn't need to. Behind him, my mother's composure was cracking at the edges. Her lips pressed tight, her posture stiff instead of poised. "You're humiliating us," she hissed at me. "No," I said calmly, "the record is." My father stepped closer, voice low and contained in anger. "You think a judge is going to side with you over us?" "I think a judge will side with the will." Deputy Harris returned, stopping a few feet away. "Everyone clear on next steps?" he asked. Daniel nodded first. "Blue Horizon will suspend all activity pending court review." The survey trucks pulled out, gravel spraying lightly behind them. Silence settled across the field again. For the first time since this started, the land felt still. Not claimed, not contested, just waiting. My parents stood at the gate without their audience now, without contractors, without momentum, without noise. My mother's voice dropped into something colder. "This isn't over." I know, because the TRO wasn't a victory. It was a pause. The real fight would happen in a courtroom, under oath, where signatures, timelines, and representations would be dissected line by line. And if the judge found that my parents had knowingly sold property they didn't legally own, it wouldn't just unwind a contract, it could unravel much more. As Blue Horizon's truck finally rolled down the drive, Daniel lowered his window. "We'll see you in court, Miss Whitmore." I met his eyes. "Yes," I said evenly, "we will." Behind me, the farmhouse porch creaked in the morning wind, and for the first time since my father said the word sold, I wasn't reacting anymore. I was prepared. Courtrooms don't feel dramatic when you're inside them. They feel quiet, controlled, predictable.
which is exactly why people who gamble on chaos usually lose there. 2 weeks after the temporary restraining order, we stood inside courtroom 3 of the Ashford County Circuit Court. The wooden benches were half full, Blue Horizon executives on one side, a few local farmers on the other. Word travels fast when land is involved. At the front sat Judge Eleanor Briggs. No theatrics, no raised voice, just a woman with a pen, a file, and the authority to untangle everything. My parents sat at the respondents' table. For the first time since this started, they weren't confident. They were calculating. Rachel stood beside me, legal pad in hand. "Today is about standing in authority," she whispered. "Nothing more, nothing less." Blue Horizons counsel, Daniel Price, opened first. "Your Honor, our client entered a purchase agreement in good faith with Thomas and Elaine Whitmore, who represented themselves as lawful heirs with authority to convey the Whitmore parcel." He was careful. He didn't overreach. He didn't accuse. He framed it as reliance. Judge Briggs nodded once. "And was probate open at the time of execution?" "No, Your Honor." She looked down at the file. Rachel stood. "Your Honor, probate was not open because the decedent's will had not yet been filed. Upon discovery, my client immediately opened probate and recorded a notice of pending action. The will names Clara Whitmore as sole devisee and executor of the farm parcel." She handed copies to the court. Judge Briggs adjusted her glasses and read silently for nearly a full minute. Silence in court feels heavier than shouting ever could. Finally, she looked up. "Mr. Whitmore," she said to my father, "did you disclose the existence of this will to Blue Horizon?" My father's throat moved once before he spoke. "There was confusion," he said carefully. "We believed—" "That wasn't my question," the judge interrupted gently. "Did you disclose the will?" "No," he said. My mother shifted in her seat. Judge Briggs turned to Blue Horizons counsel. "And did you independently verify probate status before executing a purchase agreement?" Daniel exhaled softly. "We relied on representations." The judge nodded. Then she spoke slowly, clearly, deliberately. "The court recognizes the validity of the filed will pending formal probate confirmation. The temporary restraining order remains in effect. The purchase agreement executed by Thomas and Elaine Whitmore is hereby deemed voidable pending final probate determination due to lack of demonstrated authority at time of execution." Voidable. Not dramatic, not explosive, just legally precise. My father's shoulders dropped slightly. But the judge wasn't finished. "Furthermore," she continued, "the court will schedule an evidentiary hearing to determine whether misrepresentation occurred and whether damages or sanctions are appropriate." That word landed. Sanctions. Blue Horizons' table went very still. My mother finally spoke. "This is a family matter," she said tightly. Judge Briggs looked directly at her. "It became a legal matter when property was sold without confirmed authority." Silence again. The gavel tapped once, not slammed, just concluded. Court is adjourned. Outside the courtroom, the hallway buzzed quietly. Blue Horizons executives huddled with Daniel. I could see the shift, not aggression, but risk assessment. Daniel approached us after a moment. "Miss Whitmore," he said, voice measured, "we will be re-evaluating our position." "You should," I replied calmly. He nodded once. "If misrepresentation is established, we will pursue recovery." Not from me, from the sellers. He didn't have to say it. My father stepped toward me the moment Daniel walked away. "You've made your point," he said. Anger dulled into something closer to strain. "This wasn't about a point," I answered. "It's land," my mother said sharply. "It's money." It was Grandpa's, I replied quietly, and he was clear. My father shook his head. You could have handled this privately. So could you. That stopped him. Because he knew. They both knew. This only reached a courtroom because they tried to make it irreversible before I could look. Rachel touched my arm gently. Probate confirmation hearing is next week. After that, title quieting. I nodded. Outside the courthouse, the winter air felt sharper than usual. Clean. Honest. Across the streets, the farmers who'd been watching gave small nods. Not applause. Not celebration. Recognition. In counties like Ashford, land isn't just property. It's memory. It's labor. It's intention carried across generations. And the record, unlike people, doesn't change. When the record speaks clearly enough, it doesn't need to raise its voice. A week later, probate was formally confirmed. The will stood. Title vested in my name as sole devisee and executor. Clean. Recorded. Final. The bright survey stakes disappeared from the fields within days. The no trespassing sign came down quietly. Spring would come soon. Planting season doesn't wait for family disputes. That evening, standing on the porch with the wind moving steady across the rows, I thought about what my grandfather had said. People change when land turns into money. Maybe, but not out of evil. Sometimes out of fear, out of debt, out of the slow frustration of watching something you built erode year by year. My father wasn't the villain of his own story. He was a man who made wrong choices under pressure. So was my mother. That didn't make what they did right, but it made the story truer than a simple battle between good and evil. And the record, unlike people, doesn't change. When the record speaks clearly enough, it doesn't need to raise its voice.